So now we're going to have a panel discussion followed by an audience Q&A. And our panelists are named here and described in the program, but just in case you can't read their name tags. So to my immediate right, we have Michelle Hall, Executive Director of the North Carolina Sentencing and Policy Advisory Commission, Kevin Lindsey, who is the Commissioner of the Department of Human Rights in Minnesota. We have Mary Moriarty, Chief Public Defender here in Hennepin County, the 4th District, and Dean Mazzone, who is at the Massachusetts Attorney General's Office and a member of the Massachusetts Sentencing Commission. So we actually have two Sentencing Commission people here. We also have prosecution and defense perspectives. So I hope we have the human rights perspective. So I hope we've got quite a range of views here. So what I'm going to do is initially give each of the panelists 5 minutes to make whatever comments they would like generally, reflecting on the presentation and discussion we had before the break. Any aspect of criminal history enhancements and impacts that they are particularly interested in or surprised by or want to make a comment on. So I guess I'll probably just take you in order from my immediate right, and our staffer Alexis in the red top there will give you a 2-minute warning, so we'll try to stay roughly on schedule. Of course, if you don't want to talk for a full 5 minutes, that's your choice. So Michelle?
Sure. Well, I just want to, first of all, thank the Robina Institute for putting this conference on, and I think the material that's been presented is really thought-provoking. I know that I have a lot of ideas of things that I want to further explore when I return to North Carolina. With that being said, just a brief statement about North Carolina's system. We are another guideline state, but the way that we would differ from some other jurisdictions would be that our guidelines are mandatory. So they're not recommendations. If you end up somewhere on a cell on our grid, the judge cannot deviate from that cell. So that is determined by your current conviction and your prior record level is what we would call our criminal history score. So just general talking about how prior record level has affected North Carolina's system, would be to achieve some of the goals that were originally contemplated when we enacted our Structured Sentencing Act, and that would be consistency. For one, similarly situated offenders would end up having similar outcomes, and our grid certainly has produced that as, in part helped by the criminal history measure, and has also borne out an incredibly stable and predictable system in North Carolina. The other thing that was contemplated when we were developing the offense classification and the criminal history was prioritizing prison beds, which is one of the topics that's already been mentioned. But in North Carolina, we wanted to prioritize not just for violent offenders, but for repeat offenders, and that was sort of expressed as one of the goals. So criminal history does help sort of contribute to that other principle. The other thing I would suggest is just being familiar with your system drivers for your prison population. And for us, the offense class is the driver when you consider the stacking effect over time of who's in there. And that would be your more violent offenders and the ones that are committing person offenses, and less so those with extensive criminal history. I also wanted to note, sort of just on the topic of the disparity question, that our Sentencing Commission looked back in the early 2000s at some key sort of discretionary decision points under our system to look at what factors were contributing to those decisions, both legal and what we would call extra-legal factors, such as, race, gender, age, and found that race was not a statistically significant factor at the in-out point or at any of the points that we were looking at. But I do think it's important for those types of studies to be ongoing, and we haven't repeated that study since that time. But I do think it's important. Lastly, on the sort of age crime curve, I think it's a really interesting point and something that we haven't really looked at as to how age and prior record level in North Carolina intersect. And so I would be interested in delving deeper into that particular dimension. That's what I have.
Commissioner Lindsey?
Thank you. Appreciate the opportunity to be with you today. And again, I want to also extend my congratulations to the Robina Institute. Very well done presentation for today, and the materials are outstanding once again. So hats off to you. Let me start, since we had some poetry earlier, putting the pressure on all of us. Prejudice is a burden that confuses the past, threatens the future, and renders the present inaccessible. And that's by Maya Angelou. So when I was looking at and hearing the presentation, I do see the influence of sort of how we have not always dealt with the issue of race within our respective country. And that not dealing with it in the past is confusing and impacting issues going forward. So when I heard the professor talk about at risk in the community, that assumption that we are all the same within the community has never truly been accurate. There are different circumstances as it relates to folks within the United States, and has always been since the formation of our country. And I think the failure to sort of recognize that there is discrimination, that there are barriers for individuals, and that we compound those barriers when we have the interplay and the interaction of a criminal conviction is a fallacy that we have to be willing to actually open up and discuss and be honest with one another. Because if we're not honest about that, then we're just going to continue down the same path of having disparate outcomes within this process. So I think that was the first thing that sort of jumped out to me. The second thing which sort of jumped out to me is that the issue of mental health diagnosis and individuals' disabilities. There is clearly an intersection as it relates to this enhancement of sentences and the impact of individuals within our correction systems. When I have been fortunate to have conversations with police officers about the 21st century policing model, routinely people in the law enforcement community say anywhere between, on a low end, 20%, sometimes as high as 40 or 50% of the folks that they interact with have some diagnosis of mental health issue. So to this extent that we have individuals who are committing low-level property crimes and those are adding up for them, should we also punish those individuals who have such a diagnosis more severely? Is that really sort of who we are as individuals? Is that a humane thing for us to be doing as a society? And when we're putting them in prison, are we truly, as the question was asked, are we rehabilitating them? Are we really providing them with the tools to be successful when they leave? Are we really being honest with ourselves in that space? And then I think there's this issue, too, as it relates to age over time and this look-back period. I think the professor is right when he was talking about this idea of punishing individuals beyond 10 years. And I think that unfortunately, within our country, sometimes this idea of wanting to punish is so great that it really confuses us as it relates to the risk. And we're really not punishing people we're scared of, we're punishing people we're mad at. We're punishing people we're mad at. And we have to stop doing that. We have to reallocate those resources on the front end in a lot of areas where we should be, and not be so driven by our anger to punish individuals, or for some of us to sentence individuals in a way which comports with our fallacy of sort of understanding opportunities and likelihood of success for certain communities. And I think if we do that, then we will be in a much better position, and we'll have a better criminal justice system, a better society as a whole. Thank you.
Thank you. All right.
I want to first talk about the 15-year look-back period. We know that it's 15 years from the date of discharge from probation or parole. I've been a public defender for 26 years, and my father was a public defender in southern Minnesota. I've been anecdotally aware that different cultures exist within different districts in terms of pronounced probationary length of sentences. And what I mean by that is I've known in Hennepin County, judges typically put people on probation for less time. But Kelly was kind enough to provide me with some data from the Minnesota sentencing guidelines that really illustrates this. So I asked Dean if it was okay to make him be a person addicted to drugs out in St. Cloud. Yeah. So let's say Dean and I commit a drug offense on the same date. I commit mine in Minneapolis. He commits his in St. Cloud. We are both given probation. In Hennepin County, on a drug case, I am likely to get a probationary period of 3 years. So I'm going to be put on probation for 3 years. Guess how long Dean is going to be put on probation in St. Cloud for the same offense? 10 years. So what does that mean practically? That means, let's say we both complete probation, we do the same on probation. After 3 years, my 15-year clock starts to count down. Dean has 7 more years before that clock starts to tick.
It's not fair.
It isn't fair. And by the way, Dean is disenfranchised for that 7 years. He remains on probation with probation in his hair, maybe making him come in for UAs, who knows what. But he is on probation. It may prevent him from getting a job, and I know we're going to talk about disenfranchisement later. But that is simply arbitrary, and it's simply based on the culture of the judges who impose sentences. So that's a problem when we're talking about using a look-back date that's dependent on discharge from probation. The second thing I want to talk about is this. We criminalize addiction. We do it all over the country, and we do it here in Hennepin County. We also criminalize mental health. We know that the war on drugs was a massive failure. We know that mass incarceration has devastated many of our communities of color. But our guidelines still allow for disparate sentencing or disparate impact. And here's what I mean by that. So let's say I have a cocaine addiction. I've had it for 10 years. I am a white woman. Let's say John Smith is a black man. He has had a cocaine addiction for those same 10 years. He's poor. I have some means. He lives in a poor neighborhood in Minneapolis in an apartment. I own a house. I can get high in my house. Nobody cares. I am never going to be stopped in my neighborhood in southwest Minneapolis by the police as I'm walking down the street. John may very well be stopped and frisked by the police in Minneapolis in his poor neighborhood. I drive a car without equipment problems. John Smith has a bunch of equipment violations, and he gets stopped by the police frequently, and they search him. As a result of those frequent stops and the idea that the police focus on street-level crime in poor neighborhoods, particularly drugs and guns, he is going to get caught with his cocaine far more than I am. He's going to get convicted of those, and he's going to accumulate criminal history points. I, one day, could have been this morning, although I'm going to subtract the cocaine part of it, went down, got off the crosstown, went south on Xerxes, where there's a notorious speed trap in Edina, where you think you should be going 40 miles an hour, you can only go 30. And there are cops always sitting there. So let's say I'm going 10 miles an hour with the speed limit, I get pulled over, I'm careless, I have my little packet of cocaine in plain view. I get stopped, I get charged with possession of cocaine. John Smith gets charged with possession of cocaine. Because of his criminal history, he is going to go to prison. I am not. Is that fair? We've had an addiction for the same period of time, but mine has never become public, at least to the criminal justice system, because I have means, I'm white, there are a lot of different issues. This is unfair, and it continues to decimate our communities of color. And the guidelines allow for that. So my pitch would be that we not allow any sentencing enhancements that result in racial disparate impact.
Hi, my name is Dean Mazzone. I am the Deputy Chief of the Criminal Bureau in the Massachusetts Attorney General's Office. Whatever I say, and I'm also a member of the Massachusetts Sentencing Commission, whatever I say right now, for those people recording, is just my personal opinion and is not the opinion of the Attorney General of Massachusetts nor the opinion of the Massachusetts Sentencing Commission, but I think they will agree on this. We thank the Robina Institute for incredible work it's done that has been just so helpful. Professor, Dr. Hester, Kelly, this book, to have all this compiled at your fingertips is invaluable, and for practitioners. I'm a practitioner. I run the criminal bureau, and when it comes to my job in the Sentencing Commission, the insight that's provided by the work that you've done, I can't say enough good things. So I'll stop there, but I just wanted that for all these people watching to know how awesome the Institute is. Massachusetts Sentencing Commission. We have, I don't know if you'd call us a guidelines state. I guess we have guidelines, but they are as advisory can be, which means they are out there for judges to consult or not at their leisure. Some judges really like the idea of leisure, meaning they like to decide cases on a case-by-case basis and assure us that every case is different. But as we've heard, like the difference between judicial counties, there's this constant tension between consistency, transparency, and flexibility. And I think, and not in a perfect world, but I think the guideline states are heading towards or try to achieve just that, which is what Professor Frase said, which seems like common sense to me, that it's good to have consistency, it's good to have guideposts. At the same time, there should be the ability for a judge in certain circumstances, and you would think that the judges we have are fit to do this, to make some adjustments based on the case that's before them. In Massachusetts, the prior governor recently reinvigorated the Massachusetts Sentencing Commission to update and reform the guidelines. We're doing that. It's not as easy as it sounds. We have many different stakeholders on the commission. We have defense attorneys, we have judges, we have prosecutors. We're trying our best. All we can do is recommend to the legislature certain best practices, policies, reforms of the guidelines going forward. And what we're doing with help from the Robina Institute is, formal or informal help, is we're looking at some of these, from gap and decay provisions to exactly how we count criminal history enhancements and safety valves, which we don't have when it comes to minimum mandatories, and we're trying to incorporate that into what will be our recommendations. In Massachusetts, over the past few years, for people who would support this kind of thing, there's been considerable changes in the laws when it comes to man-mins, reducing their severity. School zones, which are man-mins, it used to be 24 hours a day. Now it's 12 hours of the school zone, severely shortened. The school zone, which has led indisputably to a much less rate of conviction for those crimes, for those minimum mandatories, and that's just a fact. That's happened. When it comes to collateral consequences for convictions, another item that some people here, or a lot of people here, have shown a lot of concern for. I think the legislature over the past couple of years has done a lot to kind of pull back on just who can look at people's criminal record history information, what it can be used for, and they've kind of they've recognized that there is this issue. So there was a lot of reform a few years ago. I think people are waiting for us, also the council and state governments, our governor, chief justice, and members of the legislature tasked the council of state governments to come up with just data on Massachusetts on a whole wide range of issues. And we expect by the end of the year that they'll have not so much recommendations, or maybe recommendations, but just give us the landscape of Massachusetts and the data, and we're going to try and dovetail our recommendations into that. So, I don't know, those are the things that we're working on, and again, all these issues, rest assured, people of the Commonwealth, are being considered and will be addressed. So,
Thank you. I think it's good to underscore the wonderful diversity and variety of approaches we have, and that there are common problems that all sentencing commissions are working on, but their answers don't have to be the same, but there are common problems and some common solutions, perhaps. What I want to do now is we'll have two clusters of questions that build on the presentation this morning and also on some of the comments that have just been made. First one having to do with the justifications for these enhancements. Why is it appropriate for the person with a higher criminal history score to get a higher recommended sentence, a higher imposed sentence? And then we'll address the 4 recommendations or proposals that were in the presentations for things that might be done differently, or rules that might be adopted that most jurisdictions, or at least some of them, are not already adopting to better structure and use and limit criminal history enhancements. So let's start with justifications. I'm just going to, for these 2 segments, I'm just going to pose the questions to the panel generally and let people jump in as they wish. So as Professor Roberts discussed this morning, the 2 basic rationales, justifications for giving people higher sentences if they have more of a criminal record. One is the proxy for risk idea, the idea that as a general matter, people with higher criminal history scores have a greater risk of coming back, repeating offenses, and the other being culpability, blameworthiness, retribution. I think he used the word desert, just deserts. They all of those rationales have to do not with crime control, but just with a sense as a matter of justice and as an end in itself. People who are more blameworthy should receive more severe penalties, and their penalties should be in proportion to how blameworthy they are. So that retribution argument is very different from a risk or crime control-based argument. So let's look at risk first, and I guess I would ask the panelists to comment or say if they wish how they view the proxy for risk rationale. And Professor Roberts actually gave us 3 versions. Well, let's see. No, I'll come back to that with dessert. But the proxy for risk. Notice, by the way, that we increasingly in criminal justice are using risk assessment tools to make various decisions about whether a person should be released from prison on parole, or what kind of conditions of supervision they should have. Some pretrial release and detention. The thing about criminal history score, if we view it as a proxy for risk, we're just saying, we don't need to get into all of that, those risk assessment tools, which often include things like whether the person's employed, who they're living with, whether they have a stable residence. We're just going to look at their prior convictions, but we think that gives us a pretty good indication of their level of risk. So what do you think about that idea? Is that at least one, if not the principal rationale for these enhancements? Mary?
I think risk assessment tools are pretty dangerous, and I think there's a lot written about them, but I don't think the guidelines actually have anything to do with risk. And I'm going to give you some examples. I've represented clients for almost 26 years. I've had clients charged with very serious offenses that I really don't think were a risk, or as much of a risk as some of the clients that I've had on lower level offenses. But the guideline says some of those people charged with serious offenses should go to prison simply because of the charge. And I'm chair of the Behavioral Health Committee in our justice system in Hennepin County, and we are working a lot on mental health. And I'll tell you, it's been really hard to convince people to think about letting people with mental health issues who might have committed a more serious crime out into proper treatment. We have so many people who suffer from mental health conditions who go to prison and aren't treated there. And as a society, people are going to get out. Do we want to send mentally ill people to prison where they aren't treated and they're going to get worse when they get out? Or do we want to figure out what kind of programming they need to make sure they're healthy and can be productive members of the community. But it's a really tough battle when everybody makes the assumption that they are higher risk because they have been charged with what would be considered a more serious offense.
Any other comments on?
I would just note that there definitely is a tension between, the more severe offenses and level of risk. Our research would show that the more serious the offenders, the lower their recidivism rates as compared to your low-level felons who are big recidivators, at least in North Carolina. And the way that the criminal history measure is constructed in North Carolina would be the exact opposite of that in terms of, if you have a Class A conviction in your criminal history, which would be our most severe or most serious offense, you're going to get 10 points for that. But if you have a low-level felony, you're going to get 2. So there is a tension, I would say, between offense seriousness and your, perhaps posed level of risk.
And in two senses, actually. If you look at the grid here, you can see that, or you may be able to see that the multiplier, the ratio between the zero number and the 6 or more number is only about 50% higher at the very top there. So that's kind of consistent with those people being lower risk. On the other hand, anywhere on the grid, we weight your prior felony based on its severity level. So if we were doing it by risk, we'd want to know, well, does a person with a 2-point prior felony, that is a felony from higher on the grid, is that person riskier than a person with a half-point prior felony his prior was at the bottom of the grid, because the 2-pointer is moving across the grid faster. So there's something else going on here, it seems, besides just risk assessment. And of course, none of these formulas, except the federal one, has ever actually been validated as a risk assessment tool. In other words, you could, and they've done it, we're trying to do it now in Minnesota, you could say, let's look at the overall score and see how that correlates with whether people come back and how soon they come back. Let's look at the components and say, for each component, does this add predictive value? So we could say, yeah, we're going to give you another point because we've shown that this aspect of your prior record, your misdemeanor record, for example, makes you more likely to come back or come back for a serious crime. So to use it as actually use it as a proxy for risk, it would be nice to actually validate it that way. The federal system actually did that, and they found there was one element. It had to do with how recently were you released from your discharged from your last conviction, and if it was within 2 years, you could get an extra 2 points, the recency points. And they found that recency point didn't add any predictive value to everything else that was in the score already. It was just taking up hundreds of beds in the prison system. So they said, get rid of it. It's not cost effective. So that's one of the things you can do when you validate your score, but it's something that hasn't been done yet. So we haven't really, in a number of ways, lived up to the idea that this is a risk assessment thing. Any other comments on risk before we want to talk about desert?
I appreciate you talking about the risk piece, because when we take a look at a lot of the criminal data as it relates to crimes being committed, most are the violent crimes or crimes which are committed the person knows the other person. The likelihood of the circumstances which caused that unfortunate violent crime to happen, are they really likely to be repeated again? And then I think the other aspect of the criminal data as writ large is that there is a lot as relates to drug use. So, and the connection, which I would say the correlation between youth. And let me play that out for you. So I went to high school in Schaumburg, Illinois. Schaumburg, Illinois is a pretty affluent, mostly white suburb. I went to high school, 2,400 students. There were more black students on this panel than were in high school at that time. Okay? Some of my cousins were on the south and west side of Chicago. And what I found is that the use of recreational drugs didn't really vary between Schaumburg on Friday night or if I was downtown in Chicago among the people that I hung out there. So if you're talking about repeat bad behavior among teenagers, they tend to repeat bad behavior a lot. So to this extent as relates to catching somebody and that sort of being something that we're going to multiply and be able to predict, I would say it has nothing to do at all as relates to consequences in the criminal justice system. It has far more to do with the likelihood of resources that your parents have or the ability to shield your behavior is more likely for you to repeat that. And to the extent that people get caught within that circumstance, again, the lack of resources impacts them far greater. And let me play that out for you. So if someone goes before a judge and asks for bail, if you have resources, you're going to make bail. If you have resources, you're potentially going to have some opportunities to demonstrate to the judge you're getting your life on track. We don't have to really have the discussion as relates to if home ownership in the state of Minnesota for African Americans is only 27%, they're in a far less position to be able to make bail and create those resources. Therefore, they're going to negotiate sentencing. And that's going to start them down this path. And especially if we start talking about juveniles being caught up within the system. So to me, I guess coming attraction, right? I'm not really sure if I'm convinced really as it relates to does this grid really make sense if we're trying to use it as a predictor as it relates to predicting bad behavior in the future.
Well, and risk assessment tools also have a disparate impact on people of color and disadvantaged communities. So it isn't as if we're getting away from those problems by just looking at prior convictions. So just last quick, and then we'll go on.
Yes, yeah. I appreciate that. Sorry. Mr. Lindsey's point was a good one about, you know, you have the severity of a crime, a murder, say, or close to it. Could be an extremely localized, singular event between, you know, two people that would never be repeated again. At the same time, the gravity of that offense, you know, it just has, you know, I don't want to say surface appeal, kind of minimizes it, but just instinctively, when people look at that, that's different. And if you say, well, the likelihood of him committing not only just a crime like that, but any other crime is very low. This was a particularly unique circumstance and all that. It's a hard sell. I can say from the sentencing, from the work we're doing. When it comes to, like, say, gap decay, we can say, you know, oh, you know, this happened 20 years ago. But if it's a certain type of crime, I think it just gets people in the gut, and you can show them as many, you know, evidence-based and, you know, data results as you can, as you want or can. But it's just a very, very hard obstacle to get over.
You know, I agree. Before I was commissioner, I worked in a Ramsey County Attorney's office. So are there a percentage of individuals who come before judges that are going to be more likely to commit another violent crime? I would submit there are a certain percentage of people in our society that are more likely to commit those violent crimes. But they're nowhere as it relates to the number of people that appear every day in criminal court. We got to do a better job of identifying the people, again, that we should be scared of as opposed to we're mad at. Because the way it's set up now, we're treating all these folks in front of us as it relates to the same level of risk. There are sex offenders in our state. There are some individuals who commit violent, heinous crimes. Yes, we got to figure out and identify them, but we can't treat everybody that's before Hennepin County judges the same manner.
I guess just briefly then, let's consider the other rationale, which is just desserts, blameworthiness. So an argument could be made, some people make it, that even if you have somebody with a high criminal history score who actually doesn't have a high risk anymore, they're older, for example, or they've been treated for what the problem that was causing their crime, the retributivist would say, yes, but because they have prior convictions and now they're here again, this new crime is worse, is more culpable than if they hadn't been convicted for those other crimes back then. So we have to increase the current sentence. Even if it has nothing, even if it doesn't predict risk, it's just what they deserve because of their prior convictions, as opposed to somebody who didn't have those prior convictions. Any thoughts about that? Because it really, particularly on the weighting, I gave the example of somebody with a 2-point prior felony, and that's somebody, even if their prior conviction was a serious crime, but not the kind of crime that's repeated very often, and maybe their current crime isn't either, but the retributivist would say, because their prior crime was more serious, they are more culpable, that much more culpable, for the current crime. Right.
I'd go back to the number of clients that we have who have substance abuse problems. And does it make any sense? I mean, when you say they deserve a higher sentence because of a prior record, a lot of the prior records are driven by substance abuse. And we know that addiction is a disease. Now, certainly one makes choices, like whether they get into a car if they've been drinking, but is it okay? Do we as a society want to punish people longer because they struggle with an addiction? And so I don't think that makes much sense, particularly if you factor risk out of it and you're just talking about they deserve it. If we truly believe that addiction and mental health are diseases, then why are we punishing people for diseases?
No, just as a consensus, I think I have in my 19 years, glorious years of criminal prosecution, there is no doubt that issues you've raised like addiction are at the root of so many people with huge records. But I think, and I'll just end it, if I think there's a consensus that if these people have that abuse problem, the number one priority should be not so much punishment, but to help them with that problem. I shouldn't probably know more than I do as to what kind of services are available to people who go to jail and all that. But I think everyone can agree that that's the root problem. That should be the number one thing that we solve. So I'm speaking as a prosecutor.
All right, let's consider some of the 4 recommendations that were suggested in the presentation this morning. And I don't know whether I can, I'll read them to you. The first one said, prior record should never account for more than half of a sentence. So another way of stating that would be that even if you're all the way out in column 6, that number, the single number at the top of the cell, should never be more than twice the number at the bottom. In other words, the prior record has doubled, but no more than doubled the sentence, or the prior record is adding no more than half of the total sentence. They're the same. Whether you talk about no more than half or whether you say doubling, it's the same numbers. And in Minnesota, in the middle here, we've got a bunch of rows where it's I think in some cases it's over 3. In some jurisdictions, far more than that. So I guess this recommendation is addressed especially to the jurisdictions or to the rows on some grids that are really a huge multiplier, where criminal history is accounting for much more than half of the total sentence by the time you get out to the far right side here. So thoughts about that?
I think for me, I would be very interested as it relates to the respective crimes. I think when the professor put it up earlier that you could get 6 points and they could be all different crimes, to me, I'm thinking about the impact of poverty within our society. So to the extent that an individual, for a variety of different reasons, doesn't have the resources to sustain themselves or their family and they fall into bad behavior, is that something that we're going to sentence in the same way as an executive who has resources that might exploit the financial system and cause devastating impact to a larger number of individuals within our society? If we're talking about consequences to the greater good, to the greater public, am I as upset over that stealing that loaf of bread as relates to impacting dozens, thousands of individuals within our society? That type of connection for that individual to repeat a crime, that seems to me warrant more points or more level of sanction by the judicial officer. That seems to me to make sense.
You mean repeating a similar crime to the previous one, which is interesting. You would think, and a lot of people who write about this when they're justifying the, at least the retributive argument, they seem to assume it's the same crime. He did it again. But in fact, it could be a totally different kind of crime. It could be a less serious crime. He's making progress. At least it's a less serious crime. It all counts. So what we call patterning, that is, we enhance the current crime because it's similar to the prior crime. That's actually rare in these formulas, which is pretty remarkable. So anyway, I think we're going to have to move along here. So let me, if I can do it, get us to the next one. So this has to do with the so-called look-back or decay issue, and the idea was thrown out here twofold, two options. One was that just a flat thing, it counts fully, and then in 10 years it disappears, which is what almost all systems do. It's a cliff that you hit at some point, as opposed to a true decay where it just gets less and less weight as you go along and finally completely disappears. And there's actually two versions of these rules that I'm not sure came up this morning. One is just a pure passage of time rule that says if this is really old, even if you have been in prison this whole time, it's from an earlier time in your life. And so it's less and less relevant, at least after 15 years. Whereas the so-called gap rule, or crime-free gap, would say, and that might be a shorter period of time, we might say, if you've managed to go X years in the community, you have to be at risk, you have to be out in the community, and you've gotten this many years without any new convictions, then we won't count it anymore. So there's a sort of pure look back, just passage of years, and then there's the gap rule that focuses on you've gone this many years without a new crime. Thoughts about that?
North Carolina is one of the states that doesn't have any limitations on how far back you can look at someone's criminal history. So age of offense, or whether the offense is 15 years old, 20 years old, it could still be counted at your current conviction. Our sentencing commission did look at our prior record level and made some changes in 2009 as they relate to proportionality between prior record levels. And I think you did see earlier that North Carolina does get very close to meeting that no more than half of the sentence between the least severe and most severe prior record levels. But they did not look at the potential for having a decay or having a look-back limit at that time. So I think if there was a need in terms of prison resources, those might be some options to be considered, since we don't have anything like that at this current point.
As I said a few minutes ago, the Sentencing Commission is giving a serious look to the gap and decay provisions. We're actually having a public hearing in a couple of weeks where we will put out for public. We've already put out for public consumption, but for public comment, issues like gap and decay, and we'll see how that goes. It seems like a reasonable. A reasonable, efficacious way to go about sentencing, but we'll see how that goes.
I think it was one of the most shocking findings when we did our national survey, how many guideline systems have no limit on look back, and how many more only have it for less serious crimes, so that somebody could be, as old as me, and I'll let you guess, and what I did when I was 19 is going to send me to prison or use up a prison bed for longer. People live a long time in my family, so you're going to pay. It's not just me who's paying.
In Massachusetts, anyway, speaking purely anecdotally, people we look. Judges look at the records and they look at that. And they consider that. Or that's been my experience.
Which way?
The reasonable way is, as the professor says, if something did happen 10 or 15 years ago, that people see that. So, and again, anecdotal.
I'd go further. I think we need to be much more generous in expunging prior records. So many of our clients have a hard time getting a job, getting an apartment. So I think we really need to dramatically limit how prior convictions are used, and we need to give people an opportunity to get it expunged from their record so it doesn't continue with them, 30 years later when they're trying to get a job or an apartment or a loan or what have you.
Now, research has shown, not much on this, but what there is shows that if somebody can go for 7 years without a new conviction, even though they now have a new conviction, so you can say, well, this is an active offender. This person has not completely desisted. But somebody who's gone that long from their previous conviction has a very low likelihood of coming back yet again. So there is something in people. Desistance is like abstinence from substances. It's a relapsing problem, but people make more and more progress toward complete desistance, especially as they get older. So we need to, if we're trying to recognize that and also recognize that, we want people to be able to make a new life, not only with these enhancements, but all the stuff we're going to talk about this afternoon. Second chances, a chance to actually not be dragged back into crime in the criminal justice system. Part of that is forgiveness and wiping the slate clean. You've paid your debt. You don't have to pay again. I
just wanted to say one thing to lift up, which is different in Minnesota, the idea of somebody being on paper. Mm-hmm. So the idea that they're still on probation, that's not a time period in which the look-back period hasn't even started. So I'm on probation for 10 years, and I've got a job. I've started to go to the University of Minnesota. There's very funny professors there, so I'm enjoying all my classes, right? But the look-back period has not started. That seems to me to be an issue we should be looking at.
All right, so quickly, there were two other proposals here. One had to do with limiting juvenile priors. I would say the last option here, giving juvenile offenses less weight, is the overwhelming pattern. That is, there are a few jurisdictions that count it the same as if it was an adult crime, but most of them reduce it, recognizing that juvenile offenders are less culpable and that a certain amount of delinquency is normal behavior. Most of us actually are lucky enough to have never been caught. That doesn't mean we never did anything. But the statute of limitations is run, so I can say that now. Disregarding once the individual is 18, I guess only North Carolina doesn't count juvenile priors at all. And then there's the intermediate option where Minnesota is somewhere in there. Ours is, I guess, 7 years, not 5. So anyway, there are different options here. They all, I think, recognize that there has to be a difference, just as there is in what we do the first time around with behavior which is criminal. It matters. The person is a juvenile versus an adult. So any further questions, comments about that?
I'll just clarify for North Carolina that we don't include prior juvenile delinquency in the prior record level. However, our age of juvenile jurisdiction is 15. So once you're 16, you are an adult for criminal purposes.
Okay. Yeah. So it just shows that there's always more. Just like the look back. When do they start the clock? Here, what? How old can you be when you get these things? All right, there was one more here because I want to leave time for audience questions, but just to touch on it, whoops, that was the public opinion research, so I want to go to the judicial adjustment. So the idea being that instead of this being a rigid formula that just says whatever the numbers are, whatever the points are, that's the column of the grid that you're in, we would let courts examine, well, what kind of record is this that gave you 4 points, and so on. Any thoughts about that?
Judicial discretion upwards scares me tremendously. And it's because we work with the judges every day. We have some outstanding judges, but we also have some judges who are completely unfamiliar with poverty. I'll tell you, about 8 months ago, one of our young lawyers of color was on a jury panel in front of one of our judges in Hennepin County. And the judge asked the entire panel, do any of you know any judges? And when our lawyer raised his hand and said, I know judges, but not in person, the judge responded by saying, then you must have a record. So these are the types of things we see from some judges on a daily basis. So when we talk about judicial discretion in terms of increasing, that should scare us. It probably wouldn't surprise you that I don't have any problem with judicial decreasing it, but I think we, when we allow judges the opportunity to increase, we tend to go back into indeterminate sentencing when inappropriate things are considered.
All right, well, I think we really should get to the audience questions now. And so we're going to do it a little differently now in order to get the mics to the people who are talking, and so that I don't have to try to see people with the bright lights in my face. I feel like I'm under interrogation. We have two mics, one over there and one here. So I'd ask people to come to the mic that's closest to them, and I will just sort of alternate or go down the row from whoever's already standing there. So, and this is going to be a problem, but I think there is a... Okay, there it is. All right, so you're up.
Well, I don't know how this works, but are the points that are being accrued at sentencing considered as part of the punishment in order to make that subject to some sort of constitutional challenge as being cruel and unusual?
You mean, is the calculation of points...
considered as part of the sentence that's being given?
Well, it certainly determines the sentence.
No, those are the prior points, the points that the person is getting. So even if a person has no prior record and they're being sentenced for something here and the guideline says you get this many points, if that's rigid, you must receive those points, then is that considered part of the sentence?
Yes. And it's not an element of the crime, so the jury doesn't get into at least under current law, get into determining the facts that give you 4 points. The judge figures that out from the pre-sentence report. So that's the current law, but it is part of the punishment.
So, Professor Frase, I have a question about the idea that most people tend not to recidivate after 7 years, so there should be sort of a 7-year decay period. I think that's what you're proposing. Is that accurate, or?
I was suggesting a 7-year gap rule that after 7 years of no convictions, or since the previous conviction 7 or more years ago wouldn't count if there was no conviction in between.
But isn't the flip side of that that if people who stay law-abiding for 7 years tend not to recidivate, then if I recidivate after 8 years, haven't I shown myself to be exceptional, and shouldn't I get more of a punishment for that because perhaps I'm a little scarier than a...
Well, you certainly shown that of all the people, and so there's sometimes it's called redemption research, and that's the research which is done for purposes of collateral consequences like employment limitations. We find that, of all the people who have gone 7 or more years since their last conviction, their risk and they haven't got a new crime, their risk of a new crime.
Arrests. That's all he uses is arrests on the redemption research. Oh,
okay. Well, then it's broader.
First arrest and then re-arrest.
Okay. All right.
No conviction.
Oh, worse. So those are people who don't have a new conviction. Now, obviously, that group of people who've gone 7 years includes a subgroup who are about to commit another crime. And so those are the people that the question just asked. Well, now they've identified themselves as the riskier subgroup of these people who all went 7 years. Shouldn't we come down on them? And I guess the answer is, and again, subject to the problem of it's not looking at convictions, it's looking at arrest. That research that I'm referring to showed that even though they have a new conviction, their residual criminal career, it's called, is short and an average one more crime for the rest of their lives, as long as we followed them. So yes, they're more risky than a person who went 7 years and has not now committed a new crime. But on the other hand, they're a lot less risky than people who went a shorter period of time. That's all it says. It doesn't mean there's zero risk, but the longer they went without a new conviction, the lower their residual remaining risk.
It seems like to me this is one where we try to put everything into one silo and just ask one fact and then sort of proceed forward. I mean, all of our lives are much more complicated. So if I just went to the University of Minnesota, would it then say in 7 years this would be the outcome? No. I mean, there would be a lot of interactions as it relates to the people that I was with. Maybe I get a loan from somebody. Maybe I don't get a loan from my mom and dad as it relates to being able to put a down payment on a house. And I raise that question because to the extent that someone does time and resources are provided to them to get educated, to get a job, to find somebody to be with, that seems to me to be a far greater predictor than just sort of being released in this time period. So are we asking really the right questions? It's the issue, this is the issue. The person broke the social contract with us. And then they broke the social contract again with us 8 years later. And we're mad at them. But we got to own the other part of that contract. When they broke it the first time, did we restore the social contract with them? Did we really provide them with an opportunity to be educated, to get a job, to find a place in our society? Because if we didn't, can we really be mad at them again because they broke the social contract the second time?
Gentleman here.
So my question's not about vigilantism. It's actually a two-part question that I have. And one part is more factual based. It's for all the panelists and yourself, if you can possibly answer this for me. And then the second would be kind of more of an opinion. First of all, how do your different sentencing guidelines commission contemplate offenses from different jurisdictions? So state and municipal jurisdictions. For example, in Minneapolis, just as a side note, there's a 12-to-1 arrest disparity ratio for people who are arrested for cannabis crimes, so possession with people between people who are black and white. But in Minneapolis, up until recently, it was a misdemeanor on a municipal level, and of course, on a state level, that is a petty. So, if you look at, say, North Carolina, that's anything less than half an ounce is a Class 3 misdemeanor. In Minnesota, that's just a petty misdemeanor, and then in Massachusetts, it's a petty until it's an ounce. So I guess the question I have is, the factual question is, what and how do different states look at these crimes that may differ from state to state? Because this is a big issue with all of these states coming across, especially in 2016, 10 of them voting now on either decriminalization medical efforts or legalization efforts. And then I guess the second question I'd have would be, what do you think about blanket exclusion of these victimless crimes, or more narrowly cannabis crimes?
In North Carolina, we would count any felony that's out of state as a low-level felony, so it would be 2 points. And we don't count misdemeanors, convictions for misdemeanors in other states.
Not all misdemeanors count towards the sentencing guidelines here, so there's a list of them, and many that you're talking about, like a petty misdemeanor, wouldn't be included, or a lurking, or a spitting, or all of those kinds of things. But I think they should certainly take a look at what kind of misdemeanors are included. The answer to your question about different jurisdictions, to account for criminal history here in Minnesota, it has to have been a crime in Minnesota. So often we see things like burglary of a car from Chicago, and we don't have that here, so you have to look at the elements of the offense and see what it would be here. So it's what it would be in Minnesota.
Does it differ at all in Massachusetts, or?
Yeah, we count misdemeanors, but we'll look at everything.
Okay. Thank you.
We're running out of time. We count misdemeanors, but we'll look at everything. Sorry. We count misdemeanors.
Okay. So the time, 1 minute remaining sign has been put up, but I see. Okay, so this has to be fast. Short question, short answers.
Okay. So much has been pointed out about the recidivism rate, the types of crimes, and the crime control. It just seems to me that it should be about harm control. And so when we come, and some of this has been touched on, Federally, as a practitioner, federally, we limit the number of misdemeanor crimes, but really, if we were to just concentrate on what the harm is related to the past, and I know there's been some criticism of the actuarial test evaluations, but I think it's important to utilize them in the sense that how much harm does this individual pose, rather than necessarily what the recidivism rate is. And it just seems to me that that should be an emphasis. And I know you have to peel back this onion, it has to be legislative, because there's a lot of horrendous amounts of time being put on people who probably don't pose that type of harm. So I wonder how much emphasis is being put on what's the harm control rather than the crime control aspect of this.
Well, I think it's a really good point that federal court actually includes a lot of misdemeanors that we don't in state court. And so we've had to try to train our lawyers to make sure if somebody is pleading to a misdemeanor, it isn't of the kind that's going to affect their federal sentencing. Because I'll tell you, we're really surprised that federal court cares about disorderly conduct and other things that really have no relationship to risk or anything else.
Well, I think we're out of time, so I want to thank our panelists and thank you for your questions.